on the basis that both the legislations being pre-constitutional were essentially archaic laws not in keeping with modern societal thinking or societal values, and therefore clearly offend both Article 14 and Article 21. Some of the other cases in this category, for example, the Pravarti Educational Trust, which deals with the constitutional amendments dealing with the insertion of Article 15, subclause 5, and Article 20A by the 86th Amendment, which introduced certain provisions relating to education. Both have been upheld by the Constitution Bench. The other category of cases which you find in your list are those which pertain to judgments by larger benches, essentially on references, where the reference is either because there is a conflict in earlier decisions, or a decision of a smaller coordinate bench is doubted, and the issue is referred to a larger bench of 5 judges or more to test the correctness of a particular view. I will deal with some of those judgments, although briefly touched upon by Mr. Ramchandran, but he suggested that I may deal with them more elaborately with you. The third broad area that you find your cases that fall into are purely interpretation of statutes, but dealing largely with newer areas of law, more recent trends in the law, for example, in arbitration or the IBC, etc. Some of those Mr. Ramchandran has also dealt with. So, for example, under Section 34, you have SsangYong, and then there is a series of judgments after SsangYong, following SsangYong, explaining SsangYong. You should be familiar with those as far as what is the scope of the court under Section 34, the limited jurisdiction, etc. Similarly with IBC, though the Swiss Ribbons and SR Steel is in your list, but there has been a series of judgments after that following or explaining both these judgments, especially with reference to the rights of the committee of creditors. What do you mean by commercial wisdom? So please don't confine yourself only to those which are mentioned, but also be familiar with some of the follow-up cases that are mentioned, follow-up of those cases that are mentioned in the list. The 2 or 3 cases that I want to deal with perhaps in little more detail today, which would fall, some of them fall in what I call the second category, which is the cases which are referenced to larger benches, either doubting an earlier view or seeking to resolve a conflict. The first one of those is the Union of India versus Sriharan, the 2015 judgment, which deals with the nature of sentences in certain cases, where 7 questions were referred to the Constitution Bench, and especially one of the questions referred was with reference to the earlier judgment in Swami Shraddhanand, where in cases of 302 IPC, whether there could be a situation where rather than imposing the penalty of sentence by death, could there be a lesser sentence which would be a category that would be life imprisonment, but for a certain minimum period, and the convict would not be able to avail of the benefit of remission. So that was the limited, on that question that the matter was referred to, one of the questions referred to the larger bench. And the Constitution Bench by majority held that after reviewing the earlier case law in Maruram and other earlier judgments, that for one, life imprisonment means life imprisonment for your whole life. However, at the same time, they affirmed the view in Swami Shraddhanand and clarified that there could be a category of cases where the court could impose a punishment which would be imprisonment for life, not less than 14 years, and yet the person would not be entitled to seek remission. So that view was upheld. The view expressed in Swami Shraddhanand was also affirmed by a majority of 3:2. Additional questions were also answered in that judgment with regard to the power of the respective governments, the appropriate government, while exercising power of remission either under section 432 or 435 of the CRPC. And the court has held that three important facets have been discussed in that. One is that even though the two powers of remission that is under the Code of Criminal Procedure and the powers that may be available under the Constitution under Article 72 or Article 161, they are exclusive in that sense. And even after the power has been exercised, perhaps has been invoked under Article 72 or 161, the appropriate government could still exercise the power of remission under Section 432 of the CRPC. As far as the question of primacy of the views of the central government vis-a-vis the state government is concerned, the court has held that as far as those cases falling under section 432 subclause 7 subclause A, the union government would have primacy, while in all other cases it would be the state government that will be the appropriate government. The court also clarified that under section 432 there is no suo motu power. The provision will have to be invoked by the convict, and it is not some power that can be invoked suo motu. Lastly, on the scope of section 435 of the CRPC, court has also clarified that in those cases following under 435(1)(a) to C, which are cases which deal with certain offences relating to the union, it is the central government that will have primacy, and the union and the meaning of the word consultation that is used in section 435 will mean concurrence, drawing from earlier judgments that we have seen also in the context of the appointment of judges, where consultation is used in Article 124 of the Constitution, etc. The court has been of the view, the court came to the view that in the context of section 435, consultation must mean concurrence in this context as well. So Sriharan is an important case for these aspects on the question of the nature of sentence that can be imposed, as also the nature of the power of remission that can be exercised by respectively by the state government as well as the central government, and their inter se role in this process. The other judgment also on criminal law is the Constitutional Bench judgment in Sushila Agarwal, which relates to anticipatory bail. Now here in Sushila Agarwal, there were two streams of judgments which actually came up for consideration. There was one set of judgments like Salahuddin Sheikh, etc., which said that while granting anticipatory bail, there could be restrictive conditions, and they could be the bail could be limited in time. There was another set of judgments in Siddharam Mhatre versus State of Maharashtra that no conditions can be imposed while granting anticipatory bail. The court has considered all this trend of judgments and has unanimously resolved, although Justice Shah writes a concurring opinion, have resolved that for one, the principles of the earlier Constitution Bench in Gurbakh Singh CBR reiterated, and the factors that will weigh with the court while granting anticipatory bail will be as enunciated in CBR, namely the nature and gravity of the offence, the role of the accused, the peculiar facts of the case, etc. The court has also clarified that while granting anticipatory bail, it is always open to the court to impose certain conditions as it may feel in the facts of that case, and that is the discretion of the court. The court has also clarified that an order of anticipatory bail need not be limited in time. In fact, the court has said that an order granting anticipatory bail can even continue the conclusion of trial, and it is not necessary that in every case that the accused has to surrender at the stage when he is summoned by the court. Of course, there is a power to the police in case a situation arises under section 439 subclause 2 of the code, that in case the police feels that there is occasion to seek the convict's arrest, that can be availed of by making a necessary application under 439(2), and in that case, the police could ask for the custody of the accused. But the important facts or the important decision, part of the decision in this case are twofold. One is that the judgment in Salahuddin Sheikh and those following Salahuddin Sheikh stands overruled, which said that you cannot have any restrictive conditions or limit the time, and regarding restrictive conditions and limiting the time, and also the judgments and following those in Siddharam Maitre that no conditions can be imposed while granting bail. That has also been held to be incorrect and was overruled. The additional point in the case is that when an order of anticipatory bail is passed, that can also be questioned. And questioning an order of grant of anticipatory bail is very different from an order seeking cancellation on the ground of violation. Because an order that is granted, an order granting anticipatory bail could very well be questioned on the ground that it suffers from non-application of mind, relevant factors have not been considered, the nature of the offense has not been considered, etc. That is very different from saying that a person who has violated the condition of bail invites cancellation of the bail. So to that extent, the court has now exhaustively clarified the scope of grant of anticipatory bail, reiterated the principles earlier in Gurbakht Singh Sibia, and of course laid down these additional clarifications regarding conditions that can be imposed, regarding the time factor, that it need not be limited by time, and of course also clarified that merely because an order of anticipatory bail is granted, it does not restrict the rights of the police to continue to investigate the matter. So it should not be construed that as if a grant of anticipatory bail is some absolution for the accused and he is free to do whatever he feels like. These are the two judgments that I thought I would cover as far as on some aspects of criminal law. The other judgment, which also I believe Mr. Ramchandran briefly touched upon, but he thought I should perhaps discuss in greater detail. Sriharan, I'll answer all your questions in the chat box later, okay? If you, I'll see that in the end. The third judgment which I want to discuss is the judgment in the case of the Internet and Mobile Association, which deals with virtual currencies. Now, that's an important judgment for various reasons. Because that deals with two or three important aspects. One is it deals with a regulatory aspect in economic affairs of a regulator like the Reserve Bank of India. It also deals with certain important principles of administrative law, like malice in law and culpable exercise. And it also deals with one aspect of Article 19(1)(g), and when there is a challenge on the ground of Article 19(1)(g) on the question of proportionality and whether a measure that is taken can be questioned or to what extent can be questioned as being disproportionate while infringing a citizen's right under Article 19(1)(g). So the first aspect in the judgment was really on the role of the Reserve Bank of India and what is its functions under Section 3 of the RBI Act. Because the issue there were circulars issued by the RBI seeking to cast some restrictions on the operation of virtual currencies. And the contention raised was that, look here, you have not banned virtual currencies. Virtual currencies are still can be used. The government has not taken a call one way or the other on it. Effectively, you have banned trading in virtual currencies or what they call virtual currency exchanges. So the first ground of challenge was that the RBI doesn't have power to regulate this because this is not currency. Since it is not legal tender, it can't be called currency, and therefore RBI has no jurisdiction to regulate this. This is rejected by the court, saying that the meaning of the word currency is not just what is recognized as currency, but what is also capable of being used as fake currency or playing the role of currency. So if something is playing the role of currency, like what virtual currency seeks to do, RBI would still have the jurisdiction, would certainly have the jurisdiction to regulate and has the power to regulate under Section 3 of the Reserve Bank of India Act. The second question that was, one of the questions that was raised was, of course, of non-application of mine, but that's a decision on facts because the court found that there were various consultations and position papers and discussions in the public domain. So on facts, of course, they found that the allegation of application of mine was not made out, but that is not so important for our purpose because that was more on the factual aspects. But as far as administrative law principles are concerned, one of the challenges was on the ground that it is a malice. The exercise is a malice it suffers from malice in law and is a culpable exercise of power. Now that is rejected by the court. That is rejected by the court, saying that if someone has to succeed on the question of malice in law, you have to show bad faith. And bad faith means that the purpose is not, or the object is not to regulate the subject, but to harm those who form the target. And to succeed in showing that there is malice in law, it must be wrongful and willful without reasonable or probable cause. So that is the test that the court employed in this case as far as to test whether the action taken by the RBI suffers from malice in law. On facts, of course, the court found that there is no malice in law, it is not a culpable exercise. The additional argument that is raised in the case was that that the respondents cannot provide additional reasons in court. Now this flows from the judgment in Mohinder Singh Gill, because Mohinder Singh Gill said that an order must speak for itself and the reasons cannot be supplemented by way of affidavits or pleadings in court. The court has then drawn or noticed that the test in Mohinder Singh Gill has in a sense been expanded or diluted in two cases subsequently. One is the Indian Railway Recruitment Board case and in 63 Moons, where the courts found that where there is an overriding or a larger public interest, then that rigor that was laid down in Mohinder Singh Gill need not be followed, in the sense that there will not be a prohibition for the respondent or for the state authorities to plead or show additional material in court, and that the strict rigor that the order must speak for itself as laid down in Mohinder Singh Gill may not apply. The last aspect touched upon in the case, and that is actually ultimately the only point on which the petitioner succeeded, because all the points that I mentioned before, the court has held against the petitioners on the question of the scope of the jurisdiction of RBI under Section 3, the question of malice in law, the Mohinder Singh Gill test. On all these three aspects, the court held against the petitioners and found that there was no merit in their argument. But on the last aspect, that is, whether the action proposed to be taken by the Reserve Bank of India was proportional and whether it violated the right to business under Article 19(1)(g. On this point, the court has found in favor of the petitioners and said that for a couple of reasons. One is, admittedly, there was no ban on virtual currencies. And secondly, the government had not taken a stand officially whether virtual currencies were legal or not. So given these two scenarios, the court said that you have the proposed action that you have taken of banning trading is disproportionate and will violate Article 19(1)(g), because merely possessing the power, which the court has undoubtedly said that the power lies by virtue of Section 3 of the RBI Act. Possessing the power or the availability of the power is one thing, but its exercise is a completely different matter. So the exercise of the power was tested, and given these facts that virtual currencies are not being banned by RBI, bilateral virtual currency trading transactions were continuing. Government was yet to take a stand officially. The court held that the RBI circular in question of 2018 was disproportionate, and on this limited ground, the court granted relief to the petitioners in this case. So these are the few cases that I thought I would discuss. As I said, a large number of the other cases, some of them Mr. Ramchandran has covered, some of them might have been covered in the other lectures. If there are any specific questions or issues that you have, then I'll be happy to answer them. Which question would you like me to go from first? Someone has asked what is the paper pattern. I think Mr. Ramchandran already clarified last time. There will be a choice, and you will have to answer. I mean, there will be a choice essentially. I'm sorry, I can't answer questions whether a particular paper will come or not. A question will come or not. That would be a leading question. So please excuse me from answering that. What is the name? What is the name of the case? Either the three cases I discussed today in sequence. First was Union of India versus Sriharan, which in your list of cases is serial number 37. The second one that I discussed was Shushila Agarwal, which in your list of cases, I'll just tell you. Uh, 60. Sushila Agarwal is serial 60, and Internet and Mobile Association is serial number 62. Yes, all questions will have equal marks. Someone is saying name connected cases to SsangYong. There are a number of cases. There is PSA Sikal by Justice Gawai. There is the Delhi Metro case, which is I think authored by, it was a bench of Justice Ravindra Bhatt and Nageshwar Rao. I don't remember who the author is. And there are several judgments after that. Last time, kinds of FIR which was not discussed. The questions will all carry equal marks. I would only suggest, please pace yourself, because what tends to happen is you see one or two questions which you think you know better than the others, and then you spend a lot of time on it, and then in the end you find your rush to try and complete the paper. So you see the number of questions, see the amount of time, try and allocate your time accordingly. IBC related judgments, essentially in the list, as I said, there is Swiss Ribbons and SR Steel, but there are series of judgments after that on various aspects. As far as there are one important aspect is the issue of commercial wisdom and the role, the commercial wisdom and the role of the adjudicating authority under Section 31. There are a number of judgments that follow that deal with that, and all the judgments are in the last 2 years. You will find them easily. No, I need not write the brief facts of the case, because essentially we are focusing on a principle and the application of the principle. We are not asking for a case summary. Remission power is in Sriharan, where two or three aspects have been covered in that. The one is the aspect of 432 versus 435. Second is the aspect of um, the interplay between Article 72 and 161 and the provisions of the Code of Criminal Procedure. Now, Sriharan says that merely because you have, even after you've exercised the power under Article 72 and 161, the appropriate government can exercise powers under Section 432 and 433. As far as primacy is concerned, that is under 432 and 435, the inter se role of the central government and the state government. Yes, MS Gill test. Yes, MS Gill. What I meant in the, as far as the MS Gill test is, the MS Gill test is that the normal rule in administrative law is that when an order is challenged in court and the respondent comes to defend the order, the courts have normally held that, based on MS Gill, that the order must speak for itself. You cannot supplement that order by pleadings, etc., by furnishing additional reasons or additional answers by way of affidavits. That, to some extent, in the internet, what the Internet and Mobile Association judgment notes are the two later judgments in the Railway Board as well as 63 Moons, that where there is a larger overwhelming public interest, then in those cases or in such a situation, the MS Gill test may not be strictly adhered to or insisted upon. That's what I meant by the MS Gill test. We are not looking for quickness of reading, rather than but certainly understanding of the principles. Understanding of principles, and where it is possible or depending on the subject, that if you are aware of certain cases where the principles have been followed or approved, or that is also to your advantage. Arbitration judgments, yes, public policy. That's so basically like SsangYong, and that's and see, post the two. What is SsangYong? SsangYong is the main judgment that is after the 2015 amendment, and that then explains the legislative changes, to what extent the earlier judgments hold good, doesn't hold good, and essentially, if I remember correctly, if you read from para 36 to 41 of SsangYong, that Justice Nariman has crystallized the tests. Those have then been subsequently followed. Curative is Ashok Hurra. I think Mr. Ramchandran has already dealt with that in his. I already dealt with that in his lecture. I don't think head notes will be provided. That you have to ask the examiners. No, pleadings, I'm not saying pleadings can be substituted, but they could be additionally relied upon. I mean, it's not as a substitution, but the court has permitted that additional factors could be looked at. Any other? I can't answer whether reservation case will come or not, but the recent one that has been pronounced, that is not in the list, I can tell you that. I can't say how many paras and pages you have to write. So basic structure, I think already couple of lectures have already taken place on basic structure from what I gathered, because I think Mr. Ramchandran did some part and I think Jayant Mehta also gave some part of the lecture. But essentially you're looking at Minerva and Krishnan Bharti, as well as then the follow-up. You look at COILO, what is the effect of putting a legislation in the ninth schedule? Those are some of the important aspects. Name of the cases I've already mentioned to you: Sriharan, Sushila Agarwal, and Internet was the three that I discussed in detail. The others that I just briefly touched upon were Naftesh Johar and Joseph Shine. And in the course of question and answers today, we have dealt with SsangYong and the IBC cases. Recent cases on public policy and patent illegality. I said if you see all the cases post SsangYong, you will find there is PSA Sekal, DMRC on the Delhi Metro. There is one more recent one by in 2022. I can't get the name offhand. But there are a series of judgments on this. Public interest litigation, this is which one? I don't know. There are no specific PIL cases as far as in that sense as a topic. It's culpable exercise. What I said was from the Internet Association case that a culpable exercise of power will be one which is in bad faith. Bad faith meaning where the object is to harm the target and not to regulate. That is what the court has said. That is the meaning of culpable exercise in the context of administrative law. That is very different from culpable exercise when it comes to legislation. I'm talking about administrative law. And read with that the concept of malice in law, that it is either wrongful and willful without probable cause. Yes, I mean, Naftesh Johar will be linked to Puttaswamy and Shaira Bano because two things flow from Shaira Bano and Puttaswamy. One is manifest arbitrariness in Shaira Bano and privacy that comes from Puttaswamy. All questions will carry up equal marks. How many questions to answer, etc., all that will be in the paper. I can't tell you that much right now. No, citation is not mandatory. This is not a test of your memory. Too many questions, going very fast. Ashwini Dubey, which one is Ashwini? You mean Ashwini Kumar? Serial number 9, Chandra Kumar. The latest, if you are, as far as updates, because frequently the same question is coming, whether we need to do the follow-up and the update. If you are aware of the follow-up of the update, you will know from the question whether it is necessary to answer the follow-up and the update. But certainly if you are aware of the follow-up and update, it will be to your advantage. Specific cases, sir, I cannot tell you whether they are going to come or not. That would be, as I said, leading question. follow-ups you can easily find from SCC online. You easily get it from if you just ask for the updates. How to write a good answer? How to just think your answer through before you start writing. Focus on the principle. You are not looking to test you on your knowledge of the facts or citations and things like that. You cannot. I don't think you can write in bullet form necessarily. It may not, depending on the question, but I don't think bullet form is really the way to go about it. So when I mentioned Mr. Mehta's lecture, it was a lecture by the AOR Association. Some of you may or may not have attended. I'm not aware. Personal opinions, views, not necessarily. I mean, they're not asking for a critical analysis, because I don't think there's that much time to get into all that. But at least your understanding of whether you've understood what the essential ratio of the case is. Which topics we have tried to focus on. Some of the topics I reasonably cannot expect perhaps to tell you to read all 64 cases, given that you're all busy people. But these are broadly some of the areas. As I said, there are three categories of cases: the constitutional cases, the reference cases, and the interpretation cases. So should have some idea of all three. No, I don't think you need to get into majority and minority view, but please don't write the minority as the majority view. Don't make that mistake. So the two cases on commercial wisdom, and it starts with SR, but then thereafter there are a whole series of cases, including EBICS, and there are a number of cases that have come subsequently, both by Justice Chandrachud has written 3 or 4 of them also. No bullet points. I already clarified. I don't think you can be precise, but I don't think bullet points is an answer. Separation of power, on as far as I think perhaps Mr. Ramchandran dealt with that Ashwini Kumar's case on judicial legislation, and there is a discussion on why the court, because there the prayer was asking for a legislation in terms of some of India's international obligations, which the court has said that we cannot direct legislation to be framed. Of course, the court has noticed subsequently the 3 or 4 exceptional circumstances where the court has given directions, or if one may call it legislated, like DK Basu, where certain guidelines are there, or Vishakha, where certain guidelines are there. But there they have clarified. They have clarified that the guidelines or the directions they have given, for one, in exceptional situations, and secondly, where there is a lacuna or a gap. So, for example, Vishakha guidelines came because there was no legislation at that time. The Prevention of Sexual Harassment Act had not been legislated. So, because there was a legislative vacuum, the court said that it could pass certain. That's how it has been justified in subsequent judgments. So, that's the context. You have to read Ashwini Kumar for that.
Almost.
Whether judiciary is more active in legislation then to now, that's more of a seminar discussion. If you have less time to write, focus on what the essential principles are, what the case. I mean, if you are really running short of time, come to the crux of what the question is and what principle you are being asked for. If you can't elaborate it, but at least make sure the essential part is there. Again, leading question. Which one is Shanti conductors? If the review judgment is there, you should perhaps know what the original judgment is to understand what the context of the review. Subsequent cases I mentioned to you, I've given you some examples in the context of arbitration, in the context of IBC. As far as the Article 14, 19, 21 cases are there, most of them are covered within the list itself. Because they're starting from Maneka Gandhi, going all the way up to Navtej Johar and Puttaswamy, etc. It's okay to disagree if you can justify your personal opinion. Can we use pen and pencil for underlining? You could, I guess, there is no harm. I'm not sure if head notes are provided. You'll have to ask the examination branch. Sir, are head notes being provided to them? I'm not sure. If it's provided, that's good for you. But the only problem is with an open book, you should not get lost in trying to find what you have to answer, because you must know what the essential answer is. Otherwise, then you will waste time trying to find what the answer is. Kailash Nath is important. The Kailash Nath is important on the principles of damages. And the question whether, when you seek liquidated damages, whether actual proof is required or not. Now, partly some of the confusion is created because of the earlier judgment in ONGC versus SAW Pipes, where it seems to suggest that where there is a liquidated damages clause, there is no need for actual proof, but in actual proof of damages. So if there is a clause that says there is a breach and there will be a damages of 10%, then automatically the claimant can get 10% without proving whether actually he suffered any loss to the extent of 10%. That has been clarified, and Kailash Nath says that you must, what a liquidated damages clause provides is, it provides a limit of what the pre-estimate of damages would be. But it does not absolve the party claiming damages from proving actual loss. So you must prove actual loss. You can't go in an arbitration or a suit and say, look here, the clause says 10%, there is a breach, please give me 10% automatically. That's what Kailash Nath essentially says. And Justice Nariman in the end has summarized in 4 or 5 principles at the end of the judgment, after discussing all the earlier case law, Chunilal Mehta, etc. Gujarat Urja, I think Mr. Ramchandran dealt with Gujarat Urja along with Kailash Nath possibly. Yes, so that's what I've said. As far as Kailash Nath is concerned, the question of actual damages and estimated damages, the question is of proof. The requirement of proof is not dispensed with, essentially. That is what the essence of Kailash Nath is. Even where there is liquidated damages, a claim under a head of liquidated damages, there still has to be an element of proof that you will have to satisfy before claiming or seeking under that head. If it is not possible to determine loss, then there is maybe one exception there. But then you will have to show, you're right, there is a category carved out in Kailash Nath, then you will have to show that it is impossible to quantify the damage. But then that burden will be on the person to show that it is not possible to quantify damage, therefore liquidated damages should be as per the contract. But that burden will be there to show that it is not capable of quantification. Otherwise, the rule will be you must prove the actual damage. Cases will come from the list, but as I said, wherever possible, if you are aware of follow-up on the same topic or subsequent judgments, that will be helpful. But there will not be any straight question from outside the list. Yeah, I think you can use short forms if you want to save time. Case specific, I can't answer these questions, whether a case specific topic based, then no, background facts not required. We are not looking at I mean, except we are not looking at your knowledge of the facts of the case, citations, etc., etc. Unless you need it specifically to explain the ratio, a summary of the facts is not necessary. Again, specific cases you are asking me whether they are important or not, I really can't answer that. Average length is very difficult for me to say what should the average length be. I can't tell you in terms of pages or lines or words what the average length should be. As long as some answers may, by the virtue of the question, some may be require longer than the other, but it's not as if there is some benchmark as to what is the minimum length or the absolute length. Anything else? How many questions you will have choice? Can we close it at that? Essential cases pertaining to educational issue, TMA Pi, after TMA Pi, of course, in that line also to some extent is Pramatli, but that's on a limited question of Right to Education Act and Article 30, Subclause 1. Eight questions came. Any idea this time, Aida Jula? I can't really tell you that. Yes, wherever a case is mentioned, we have, I think, mentioned the citation, so you will not have a problem. Joseph Shine is essentially about the validity of section 497 IPC and adultery, and the court struck it down for the reason that, for one, it said that it is manifestly arbitrary. It is an archaic. It encapsulates an archaic thought system where you are not really penalizing the person for the act of adultery, but you are. It is essentially treating the woman as the chattel of the husband, and that the court said is completely abhorrent to the principle of equality and struck it down. That's one of the reasons why it struck it down. Joseph Shine essentially 14 and 21. Anything else? Can we close this now? I can't tell you which one specifically is more important than the other, but no, NJAC, what do you want me to say about NJAC? Exam pattern, there will be choice. What is the issue in NJAC? That itself. Indore development on section 24 essentially on the question of lapse and 24.2. So there are some important aspects discussed in Indore development as first of all, what is the concept of possession? When possession can be, because what was the issue essentially, why in Pune Municipal Corporation, etc., that the acquisitions were struck down? Because either the court felt that the possession was not taken or compensation was not paid. So on both aspects, the court has clarified as to what would possession mean. And secondly, what do you mean by the payment of the compensation? Whether deposit in court is sufficient, to what extent offering to the other side is sufficient, or does it mean that it should be actually paid? So the important part in 24.2 is the aspect of how possession is to be determined, as well as what is the meaning of payment and within the meaning of 20 or offering to make that payment under 24.2. Government and judiciary at loggerheads, who will have the say? The judgment is clear. If they send it back the second time, according to the judgment as it stands today, the judiciary has to have precedence. Can we now close this, please? I'm sure you will get extra sheets. Thank you very much, and I hope I was of some assistance to you, and all the best for the exam.
Thank you, sir. Thank you.